Warm greetings for the assignment of interpretation of statute. Our topic is Dworkin theory of interpretation, and our group members are Akansha Upadhyay, Khushi Agarwal, Ojashvi Yeshani, and Vedanki Mehrolia.
In order to understand Dworkin's theory of interpretation, firstly we have to understand the thought process of Dworkin, that what compelled him to develop the theory of constructive interpretation, and then we will understand the three stages of the said theory and what Dworkin meant by law as an integrity, etc. The question of how we approach the phenomenon called law is perhaps a root of the entire discipline of legal philosophy. The interpretation of world legal positivism is the point of conflict. Various philosophers has their own version of legal positivism, which we will see in further slides. The expression legal positivism has been used in many different senses by different scholars in their work. Essentially speaking, the word positivism derives its meaning from Latin word positive, which means law as it is laid down or posted. In a very crisp form, as you can see on the slide, that legal positivism is consists of two elements. First, that the existence and content of law depends entirely on social facts and there is no connection between law and morality. Now, if we see Austin's theory of law, he identified various rules that govern human conduct. He recognized that some laws are set for human by God, which are not morally acceptable but binding on humans. This he called divine law. Other thing he explained that other law which are made by human for each other, these he called positive laws. And all other standards, ethic, custom or international tradition as a source of law are not proper law according to him. He recognized law as proper only when it is recognized by any sovereign or authority. Now coming to H.L.A. Hart, he criticized Austin and gave a broader definition of legal positivism, aka law. He said that law are rule made by humans. He presented the rule of recognition as an ultimate criterion to draw legitimacy from a legal system. He said that rules come from society and it does not need any ratification by any sovereign to be considered as law, and those rules are enforceable and have sanction also. He also recognized law that were imposed by legislation, and he believed that justice can be provided by strictly sticking to the rule. Now, H.L. Hart talks about law as it is. Like, no matter whether law is correct or wrong, we have to follow it. Although he rejects law as a command, but he accepts that there is no relationship between laws and morals. Here Dworkin comes into the picture. Now to understand Dworkin's theory of interpretation or constructive interpretation, we first need to understand how Dworkin came up with the concept of constructive interpretation, or what was his thought process as discussed earlier. For the introduction purpose, Ronald Dworkin was American philosopher, jurist, and scholar of United States constitutional law. He was born in 1931 and died in 2013. Some of the famous work were Laws Empires, Taking Right Seriously, and Principal Matters. Dworkin criticized hard that rules he has been talking about can be uncertain as it is made or developed by a group of people only, and there is a high chance that it can be inconsistent. Then by giving example that earlier in the definition of vehicle, aeroplane was not included. But when aeroplane was introduced in market, judges by their power of discretion included it in the ambit of vehicle. That's why Hart is wrong when he's saying that we should follow every law no matter whether it is correct or wrong. As per Dworkin, interpretation is necessary for the same cause. Then he criticized Hart that, okay, if you're saying that we should stick to the rule as it is, then it's fine in the majority of cases as the rule is clear. For example, if one will commit theft, then he will be fined or imprisoned. Or simple things like asserting the age of president. Then he further said that how will a judge decide or find the right answer in hard cases? He explained by giving example of case of Rigg versus Palmer, where a grandfather wrote his will of inheritance in favor of his grandson, and later the same grandson murdered him. The court came to the conclusion the grandson will not be able to inherit the property, as there is a rule and a maxim that says no man can benefit from his own wrong. Dworkin questioned the right of grandfather to execute his will is ignored. He further added that we cannot rely on just discretion, as they are also human beings and they can be swayed by many factors like his own thought process or maybe his prejudice, etc. That's why he said in order to find right answer, any rule should be interpreted and of course not in isolation, and the same should be a constructive interpretation. For that he had laid some stages. He said that principle and morality should be considered and included as the legal system is itself based on certain principles and that societal norms are based on morality only. He further added while deciding a case, Hercules should make sure that there is integrity and no inconsistency.
Now we're going to understand furthermore about the concept of constructive interpretation, where Dawkins suggests that legal rights and duties are determined interpretation of certain principles which provide the best justification to the political practices of a community. In constructive interpretation, certain meaning or value is assigned to an object, taking into account whether such meaning or value really fit the object. Here, the object in general is any social practice. Dawkins believed that a judge must use the right conception of the rule of law in light of moral principle to form better interpretation of a community's customs. But the question arises that whether judges can use principles that are independent of the morals of a community. To do so, they must make sure to explain why such interpretations are needed to explain these complex constitutional rules and also justify them through the political morality of that community. Dawkins says that the interpretation of the Constitution must be done by keeping in mind that we cannot second guess the thought process or psychology of the Parliament. Hence, clause read literally can mean different through interpretation from what the framers had in mind. Hence, to provide the right judgment or interpretation of a rule, a judge must depend on the previous interpretation made by judges in the past.
Let's learn about law as integrity. Law as integrity holds a vision for judges which states that as far as possible, judges should identify legal rights and duties on the assumption that they were all created by the community as an entity and that they express the community's conception of justice and fairness. According to law as integrity, propositions of law are true if they figure in or follow from the principles of justice, fairness, and procedural due process, which provide the best constructive interpretation of the community's legal practice. Law's integrity states that the law must speak with one voice, so judges must assume that the law is structured on coherent principles about justice, fairness, and procedural due process, and that in all fresh cases which comes before them, judges must enforce these so as to make each person's situation fair and just by the same standard, that is to say, treat everyone equally. Dworkin argues that law as integrity offers a blueprint for adjudicator which directs judges to decide cases by using the same methodology from which integrity was derived, that is, constructive interpretation. Integrity is both a legislative and an adjudicative principle. Legislative principle requires lawmakers to try to make the laws morally coherent. Lawmakers are required to ask the assumption that integrity is a distinct ideals of politics for politics and honors politics. If it fits these dimensions, then adjudicative principles is ready to begin. Central to Dworkin's project that to develop a theory of adjudication, it is necessary to engage in a constructive interpretation of legal practice. Adjudicative principles instruct that the law be seen as coherent in that way as far as possible. Constructive interpretation is a methodology for interpreting social practices, texts, and work of art. The distinctive feature of this is that it is argumentative. Law's integrity sees the law as coherent whole. Law's integrity requires the judges to go through the whole law to consider an interpretation. The interpreted law as integrity holds that judges would both fit and justify what has gone on before as far as possible. Law as integrity provides a consistency in principle which requires that various standards governing the state's use of coercion against the citizen be consistent in order to have a single vision of justice. Law as integrity sees the law as a coherent phenomenon rather than a set of discrete decisions.
The right answer thesis. By the right answer thesis, Dworkin means that there will be necessary answer for each individual if he applies himself correctly to the legal question. Hercules, which is a metaphor for the best judge of all, as Dworkin describes him, is required to construct the theory that best fits and justifies the law in order to decide any case. But Hercules can also fail at reaching the right answer. Competent lawyers may disagree on the given right answer, which Dworkin recognizes, and of the view that there are circumstances where Hercules might not be able to say which one is the right answer. Hence, to summarize the idea of the right answer thesis, the law must be properly interpreted to reach an answer. Everyone may not have the same answer, but it means that there will be a necessary answer for each individual if he applies himself correctly to the legal question.
Dawkins' theory of law has developed significantly over time. The focus here is on the most comprehensive version to date outlined in Law's Empire. In that work, Dworkin famously analyzes judicial decision making as comprising three stages. The three analytical stages of constructive interpretation are: number one, pre interpretive stage. In the pre interpretive stage, a participant identifies the rules and standards that constitute the practice. The rules and standards that hold relevance for the case at hand are tentatively identified. Number two, interpretive stage. In the interpretive stage, the interpreter settles on some general justification for those elements identified at the pre interpretive stage. The judge formulates a general theory of the motivations and rationales underlying the elements of practice identified in the previous stage. Number three, post interpretive stage. At the post interpretive stage, participant adjusts his sense of what the practice really requires so as to better serve the justification he accepts at the interpretive stage. The judge forms a view about what decision the prevailing social practice requires in the present case, taking into account the general framework of justification posited at the preceding step. Of the three stages, the interpretive stage is the preeminent. The proposal must satisfy two dimensions. It must be consistent with the data identified as constituting the practice as at the pre-interpretive stage. Number two, it must choose a justification that he believes shows it in the best light. For Dworkin, the historical legal record must constitute the source of legal interpretation. This interpretation must fit into the existing both of legal materials. It should not be thought that a judge committed to law as integrity is required to interpret laws in the light of the purposes which gave rise to them. On the contrary, He is required to impose order over doctrine, not to discover order in the forces that created it.
Constructive interpretation in contemporary cases. In certain cases, like Shaira Banu versus Union of India and Indian Young Lawyer Association versus State of Kerala, better known as Sabrimala case, the court has applied this concept and found out that our constitution has willed that dignity, liberty, and equality serve as a guiding light for individuals, the state, and this court. Though our Constitution protects religious freedom and consequent rights and practices essential to religion, this court would be guided by the pursuit to uphold the value of the Constitution based in dignity, liberty, and equality. In a constitutional order of priorities, these are values on which the edifice of Constitution stands. They infuse constitutional order with a vision for the future of a just, equal, and dignified society. Intrinsic to these values was the anti exclusion principle. Exclusion was destructive of dignity, and to exclude a woman from the might of worship or right to divorce is fundamentally at odds with the constitutional value.